Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. There seems to be a serious outbreak of stupid in the trials that we're hearing about this week. We had the whole debacle in Atlanta with Judge Glanville and Brian Steele and the Georgia Supreme Court. That certainly made for interesting copy. And then today we have the story coming out of Mississippi in another murder trial where people they're either uninformed or they don't understand how the world works. I'm not sure which of those two it is. For some reason, people continue to make really dumb statements on jail telephones. As everybody should know at this point, based on the numerous different trials, not the least of which is Hannah Gutierrez Reed's trial, jail telephones are monitored and recorded. Every call between every person in the jail and somebody outside the jail is recorded. And the reason that is done is to protect the integrity of the judicial process. Now, after somebody's been convicted, it's of less import, although it could still be used against them in their appeal. Before conviction, anything you say can and will be used against you in a court of law, and that is especially true on a jail telephone system. You are using the jail's system. The jail has custody of your body, and they can record everything you say. There's absolutely no problem with that. And even if you talk in code to your compadres, the fact of the matter is you are going to get busted. Several years ago, I was involved in a case in Mississippi, and one of the issues in that case was a lawyer who was trying to do... Mississippi has some wonderful phrases for how this works. They call it earwigging, and it is basically having an ex parte meeting with a judge over an issue. In other words, you're buttonholing the judge, you're talking about an issue in your case, they sit down and they listen to you, and perhaps sometimes you work something out, especially if it's to the detriment of the other side. The idea that you would allow earwigging or ex parte conversations in any respect is ridiculous. And as far as I'm concerned, in that particular case, the judge taking the meeting was the first error. But in this case, what the guy did was he went in and he said, Judge, we really need you to rule this way. And, there would be a great deal of thanks coming your way if you did. So the judge said, let me think about it, sent the guy out of the room. First thing he did was call the FBI. The FBI came in, wired up his chambers, and when the guy came back in, he said, well, I've thought about it. I suppose I could do that. He said, well, how many sweet potatoes would you need to kind of get that taken care of? Thinking, he's being really clever here. So how many sweet potatoes? Yeah, nobody's going to figure out that you're talking about money, particularly when the judge says 20,000 sweet potatoes, right? He's recorded on audio and video saying, how many sweet potatoes do you need? I'll get them to you. And as a result, he and the other lawyers that were involved in that particular case were arrested, and they were tried for a number of different crimes, including theft of honest services. It was a pretty huge debacle, and it's one of those things, one of the reasons why I know you don't do ex parte conversations with judges ever. The only time I've ever had an ex parte conversation with a judge is when I went in to get a temporary restraining order. That's one of the exceptions where you can meet with a judge because you haven't served the other party yet. You're not even going to tell the other party until you get this temporary restraining order. But in order to do that, you have to be honest, and you have to tell the judge all the facts, not just the ones that hurt, that help you. You have to include any negative facts that are in there, because if you don't, that's an ethical violation. You can be sanctioned for it. But in this particular case, the problem isn't lawyers earwigging the judge. It's the fact that this particular judge is really upset that a couple of people have been conspiring over the phone, over the doggone jail telephone, to provide false testimony in this case, and it's a murder case. And as a result, when you conspire to commit perjury, you make yourself basically an accessory after the fact. This is not going to end well. Let's take a look at the video.
We're now on the record again in cause number 23-514, State of Mississippi versus Jordan Cummins. The court has been advised that several rules and orders of this court have been violated during this trial. The court received information from the district attorney's office that on yesterday evening, prospective witness Jenny Lukens and a prospective witness Emerson, I'm sorry, give me her name again. Lindsay Emerson were recorded on a phone call with the jail. And during that phone call, Ms. Emerson proceeded to provide Ms. Lukens with a play-by-play of the testimony in this case. That is a violation of the rule against sequestration and is also considered witness tampering and an attempt to hinder prosecution. The court has further been informed that on yesterday evening that the mother of the defendant, Mr. Cummins, was on a phone conversation with Mr. Cummins and Ms. Lukens discussing the testimony in this trial. That is considered tampering with the witness, subordination of perjury, hindering prosecution, and direct violation of this court's rule in which I stated that any persons who were subpoenaed were to be secluded and excluded from the courtroom. Mr. Kellum, what is Ms. Cummins, your client's mother's name?
Her name is Angie Kellum.
Ms. Kellum, if you'll come forward. Subordination of perjury is a criminal crime. Criminal offense is found in section 97-963 of the Mississippi Code. Giving a prospective witness information in regard to the testimony in this trial is also considered tampering with the witness and an attempt to hinder the prosecution of that witness. The court has several options available to it. The first is that the court deems that you have committed criminal violations and you're going to be surrendered into the custody of the Hinds County Sheriff's Department immediately. Upon your release, you are to come back to this court because you're considered to be in contempt, and you'll be given a court date to come back for a hearing to find whether or not you are in contempt of this court's order. Should this court find that you are in contempt, you could be fined and or jailed. The court is directing that until this case is concluded, that you are prohibited from coming to the Hinds County Circuit Court building. Do you understand that? I asked the sheriff to remand her into custody. Judge McDaniel can set a bond on this matter should the state go ahead and file the charges against this defendant for the section she has violated the Mississippi Criminal Code.
Well, there you have it. It's just not a very smart thing. The lady gets arrested, and I'm sure that there will be consequences in the end. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff. And of course, if you have the opportunity today, go out of your way, do something nice for somebody. Thank you so much for watching. Come on back here tomorrow. Catch me down here at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.